Welcome back, everybody, to another installment, actually the final installment of our Cybersecurity Fall Conference here at the Salt Lake Chamber. I'm Nick Dunn with the Chamber. I want to thank you all for joining us today and for all the previous conferences. We've been doing these each Wednesday in October and November, talking about all different aspects of cybersecurity for businesses to implement today. So today being the final webinar presentation, we are pleased to welcome Romain Marshall from Stoll Reeves. He'll be talking about cybersecurity and the evolving legal landscape. Now, before we get started with Romain, I want to remind everyone that we've been tracking the participants for this series, and those of you who have attended these webinars will be entered into an opportunity drawing for a Series 5 Apple Watch generously contributed by Strong Connections. We'll do that drawing at a future time and reach out to the person who won. We want to thank you guys again for attending all of these. And as we go through the presentation, as Romain talks about the content he's presenting today, remember to think of any questions or thoughts that you have and plug them into the Q&A tab here in the Zoom platform. Following the presentation from Romain, we'll have an opportunity to do a little discussion and have some Q&A back and forth about the content that he presents today. So with that, I'll turn the time over to Romain Marshall with Stoll Reeves talking about cybersecurity and the evolving legal landscape. Romain?
Great, thanks very much, Nick. Let me orient everyone to the screen and my PowerPoint presentation. Good afternoon, everyone. I'm coming to you today from my office downtown on the corner of Main and 2nd South. I'm also coming to you from the perspective of a lawyer. I know most of you out there are business folks in various capacities, and that the legal parts of what you do is just one slice of many other things you do. So to further orient you, my comments and presentation today comes from the perspective of someone who is used to being in a courtroom or helping clients through business disputes. And over the last 5 to 6 years, I have kind of just forged a specialization within that broad category of helping companies that get hacked and then get sued as a result. And then it has brought on from there to helping companies before they get hacked be in a position to say, when they are hacked and get sued or investigated, that they essentially did everything they could, or at least from a legal standpoint, were prepared. They weren't caught flat-footed. They understood the risks that are out there by using networks, computers, by relying on data so much, and they were prepared for it. So I'm coming from that narrow perspective with my comments to you today to kind of help and crystallize some of the things you've already heard and been listening to at prior conferences. Okay. And the reason any of this matters to all of us is the importance of data. It's funny how many times I've heard it referred to so many different things. Oil, electricity, a form of currency. Here's a quote about it being referred to as gold, but it's also been referred to as plutonium. You know, amazingly powerful, but dangerous when it spreads and difficult to clean up with serious consequences. That importance of data has evolved into the legal context into two areas of law that are distinct, and I just want to differentiate. So there's data privacy law, and that is the legal requirements relating to what a company should do with the information they have and the limits they have on how they use the data. Cybersecurity law just relates to a company's obligations to secure that data. Both these areas are governed by a patchwork of laws that make it very confusing. And as a result, keep me really, really busy. And one of the examples, just one of the dozens, if not hundreds of examples that data can intersect with legal obligations is this. I've been involved with hundreds of different types of incidents, and this is just an example of one. And it's hopefully the type of incident that none of you have been through before, but this is a screenshot from a client that experienced a ransomware attack. And this was the note that was left. And this is what the client had to work through in order to get access back to their data. How much is what the technical consultant I hired, a former FBI agent, asked the hackers. And then those negotiations continued on for several days. A ransom was paid, and then access was given back to my client. And then they had to go through the laborious task of learning or investigating whether the hackers had access to information that required them to then notify owners of that information about this incident. So this is just one type of incident that has legal ramifications. And these legal ramifications are enforced in two ways, primarily through courts and litigation that may result from a consumer or an employee whose information may have been involved or compromised during this type of attack, and then also regulatory bodies. To me, the main enforcer is the Federal Trade Commission. I've actually had a few experiences with the Commission. Last summer, went and met with FTC Commissioners. This is a statute that's outside the FTC Commission building. I think it's really cool. It's supposed to represent the horse, representing big business, with its energy and suggesting that it could easily go on a rampage and leave a path of destruction, oblivious to its own actions. And then the man trying to grip and rein it in, which symbolizes kind of the role of the FTC, which is to restrain trade from running amok and causing more damage than benefits. The FTC has this vision of ensuring that consumers have access to accurate information. They are established to protect consumers, and there's a specific section within the FTC Act that prohibits unfair methods of competition and unfair or deceptive acts or practices. So in a cybersecurity context, if a company suffers a cybersecurity incident that exposes personal information of, say, consumers or employees or business partners, the FTC has the authority to come after you and at least conduct an investigation under this second bullet. It will say, we have authority to investigate you because we need to know whether or not you've been unfair or deceptive in the way you've handled consumer information. Unfair in not having certain protections in place, deceptive in saying to consumers, we've got state-of-the-art security, don't worry, your information, such as your credit card information, social security numbers, driver's licenses, those things are safe with us. The FTC will commence an investigation in some instances when a data breach has happened by saying you were deceptive in the way you treated consumer information. And so that's their authority. This is their basic org chart. The FTC is comprised of about 1,000 employees. Only about 40 of them are lawyers, which is incredible when you think about they are required to regulate trillions and trillions of dollars that pass hands from consumers to corporations, and they only have 40 lawyers. I have more than 40 lawyers just in my Salt Lake City office. But they have hundreds of other employees who are, say, technologists, analysts, IT people who support those attorneys in their role. They are led by a gentleman named Joseph Simons, and they have 5 commissioners. Simons is one, Phillips is another, Rebecca Slaughter is one, Christine Wilson is another, and Commissioner, I think it's Rohit Chopra is another. 4 of the 5 are lawyers. Commissioner Chopra is not, but he has a very strong business background, and they oversee enforcement, and each of them has a staff that works up the cases and the investigations for these 5 commissioners to eventually make decisions on. The case I was involved with last year, which required a meeting with each of the commissioners, stemmed from a data breach which took place in 2016. Several months later, my client received a notice saying we're going to investigate, and then over a 2-year period, they were investigated, and then a meeting was held to discuss, among other things, whether or not, or basically what the settlement terms were going to be, and for that particular client. The case was settled. And the thing I want to direct your attention to that I think is most important was the FTC chairman came into the room with me and my clients. We had a 1-hour meeting with each of the 5 commissioners. And he asked this question, and he said, prior to the data breach happening, the CEO, former CEO of your company needed to have asked people within the company these questions. What are the industry standards? And this is in relation to cybersecurity, and are we meeting them? These are the questions that Chairman Simons said needed to be asked, and because they weren't, they wanted to hold us liable or have us enter into a settlement. By the way, this was a very favorable settlement. There was no penalty paid, and we simply agreed to implement cybersecurity measures that we had already implemented since the incident that occurred in 2016. But what I want to direct your attention to now is some of the other settlements that the FTC entered into last year that can serve as industry standards that those of us who have cybersecurity programs should follow. Equifax was the big settlement relating to a cybersecurity incident last year. Equifax agreed to pay, it was over $500 million, over a $500 million fine. But the more helpful part of the settlement is if you were to Google Equifax settlement with FTC, you would be led to a document that is titled a consent decree. And in that consent decree, there are all these things that Equifax promised the FTC it would do. And there's about 50 technical requirements relating to their cybersecurity program, or what the FTC refers to as a written information security program, or a WISP. The FTC basically mandated that Equifax implement one, and that it include the technical requirements that are within that document. And IT staff who are on this call, chief information security officers, even information officers, will find that interesting. We don't have the time to cover that in detail today, but those are the industry standards that the commissioner asked me and my client we need to be asking ourselves. What are the industry standards and what are we doing to meet them? Just some of the standards include things like you got to train your personnel who handle personal data on security. You got to make them aware of the risks. You've got to have vulnerability management program as part of your overall WISP. You got to have network intrusion detection, all the technical things that our IT staff and teammates understand very, very well. Those were the basic terms of it. An important side note to this was, in the settlement, FTC required Equifax to have a senior officer that reports to a board every 12 months about the status of the program. And then that same senior officer is required to cooperate with an assessor who provides that assessment to the FTC that basically says they are complying with what they said they would in the consent decree that they signed. And they have to certify to that every year for 20 years. Typically, if they do good for 5 years, then it will end. But that's just an example of legal requirements that are quite stringent as a result of cybersecurity not being taken seriously. The 5 commissioners had to vote and approve the settlement. Only 3 of them did. Commissioner Slaughter and Chopra were against it. They thought that it was too lenient. And these are statements that they both released that I think we need to be aware of as a possible direction and trend that's taking place throughout the laws that are being passed. Commissioner Slaughter said Equifax alleged violations included failures to address unpatched critical and high-risk vulnerabilities across systems. And then she also said, under the terms of the consent order, basically, she felt they were getting off too easily. And she said, if you work for Equifax and you don't think your bosses or your company is following the terms of the settlement, file a complaint. And in fact, anyone on this call who's working somewhere can file complaints with the FTC about the security posture that your company or corporation is following. Chopra, and then 2 days later, this is last summer, or July 2019, 2 days after the Equifax settlement, the FTC announced a settlement with Facebook. Now, the Facebook settlement didn't have to do with cybersecurity violations. It had to do with data privacy violations. In other words, misuse or overuse of personal data that they had collected, or misrepresenting what they said they would do with that data once they had it. So once you signed up and opened up a Facebook account, there were things that Facebook said in their privacy policies that they said they would not do with your information, including who they were going to share it with. The FTC investigated them, said they had violated what they said they would do, and then entered into a settlement that included these technical requirements. I highlight the technical requirements because, again, those are the industry standards that become the things by which you will be judged for any legal liability. So what typically happens is a consumer, once they've suffered, once one of their retailers has suffered a data breach, will file suit and they will allege that the retailer was negligent. And they will say negligence was based on the failure to implement reasonable security. And the FTC is saying reasonable security in the Equifax case should include at least those technical requirements they laid out in the consent order. In this Facebook case relating to data privacy, they set forth 30 requirements. Just like in the Equifax case, 2 of the commissioners disagreed. They wanted personal liability for executives. They wanted executives to be held liable for misuse of information or data breaches. And Chopra released this statement, I think it was on the same day as the FTC released its decision and settlement. Both he and Commissioner Slaughter are active on Twitter, and I actually follow them and find their tweets to be informative and helpful for me in counseling clients. The FTC also required this, and this is unusual and a step up from what is typical. They said Zuckerberg has to quarterly certify in writing that they are following what they said or agreed to follow in the consent order. And if he doesn't, potentially, or if he does certify and they're not, he could go to jail. Now, it's a stretch that would actually happen, but it puts some emphasis on a CEO and other executives having to know what their company is doing and making sure they're in compliance with technical requirements deemed to be industry standards, deemed to be those standards that need to be complied with to avoid legal liability. So these are instances of the FTC being the main regulator, main enforcer. About a month later, they then settled another lawsuit with Google relating to similar allegations to the Facebook case about misuse or overuse of personal information of its users. In other words, sharing it with some of their third parties. And another whopping settlement was entered into. Those cases can seem a little unrelatable because they involve such large amounts of data and such heavy fines. But I think, again, I want to emphasize the technical requirements that they agreed to implement are helpful and useful and should be things that your companies study and then can consult with the lawyer to say, hey, okay, let's say we don't have a budget that enables us to have a person who all they do is monitor patching. What's still going to help us meet the industry standard as it relates to our legal liability? That's where those decisions are helpful. As you know, every state, or as you may know, every state has a data breach notification statute. This adds to the confusion of cybersecurity law. So if you have consumers in every state and you suffer a data breach that affects consumers in every state, you have to notify them in mostly the same way, but some states are different. For example, if you have a consumer in Washington or North Dakota, if their date of birth and their name was exposed, you have to tell them. Other states don't require that. Other states generally will require notification if their name was lost or compromised in combination with, say, their social security number or their driver's license or their credit card information. Some states expand that to include health information. So you've got all these statutes that add to the confusion and require companies to at least have a program in place that's addressing these. Many of you will have heard of and maybe are having to accommodate California consumers who have rights under the California Consumer Privacy Act. While this is getting into privacy, which is not the focus of our discussion today, there's a part of this act that requires reasonable security. And it enables California consumers who feel that their information may have been compromised to ask of a company who had their information whether or not they have reasonable security. And if they don't, they can actually sue them for it. So the question then becomes, what's reasonable security? Reasonable security is some of what, at the very least, the industry standards I covered, which are included in some of the decisions that the FTC and settlements the FTC entered into last year, and such as in the Equifax case, which set forth about 30 different technical requirements. And I'm going to discuss, if there's time, what some of those requirements are. But California has said there's this new statute. The AG has said we will look kindly on those that at least demonstrate an effort to comply. In other words, if you do nothing, if you don't have if you've done nothing about looking at your systems to make a determination as to whether or not they have reasonable security, you're probably someone the AG is going to come after if you have an incident that exposes information. Just last month, well, 3 weeks ago, California enacted, or voters agreed, that a new statute, which will go into effect in 2023, should be passed. It's establishing, or will establish, kind of an FTC at the state level that will enforce consumer privacy rights, and part of those rights include security of their information. And so what's Utah doing about cybersecurity and laws? Of course, anyone can bring suit against a company they allege lost their information or caused their personal information to be compromised. They can sue under a basic theory of negligence. But when there is a law established more specifically, that gives those people more rights. And Utah is kind of forward-looking when it comes to this in comparison to other states. They have these two laws highlighted in those first two bullets passed in the last 2 to 3 years. They were considering passage of this third law, Cybersecurity Affirmative Defense Act, this year. It didn't pass, but to me, it was very surprising that they were even considering it, because what the law would have provided, and it may come up again next year and be passed, is it would have provided essentially a safe harbor for companies that suffer a data breach, or it is alleged against them they have lost someone's information. This act would create a safe harbor if they have a written cybersecurity program that included certain things. For example, included in the program these safeguards, or safeguards designed to do these things: protect the security and confidentiality of information, protect against any anticipated threats, and also protects against data breach of personal information. Essentially, implement programs and safeguards that relate to assessments the company has done of their systems, and whether or not the information they collect is being properly protected. So Utah is ahead of the majority of states in looking at these issues and having laws that guide companies on compliance and also give rights to consumers. So just to recap and to address in a nutshell what the title of this presentation has been: cybersecurity and the evolving legal landscape. There's a main enforcer, the FTC, who has entered into massive settlements with big companies that have either suffered a data breach or misused or overused information. And in those decisions, they've released technical requirements. And as part of those requirements, the FTC is saying, these are industry standards. These are industry standards that, if not implemented, can create legal liability. And states have followed suit. California being the first one that has a statute that says you got to have reasonable security. Utah's statute says you've got to, without going into detail, you've got to protect information. It doesn't say how, but industry standards establish the how. And those industry standards need to be studied and implemented for your companies. There's no one size fits all. The main thing is that you as a company are looking at it, and the best way to do that is through a risk assessment. And I'm sure that's been something that's been discussed in prior conferences. It is a risk assessment, and that process itself warrants an entire presentation. They can be laborious depending on the data and information that you collect. But the direction all of this is going, it's going to require more oversight from executives. It's going to require the formation of committees that are looking into this and looking into the risks and vulnerabilities that a company faces with the type of data they collect, maintain, and manage going forward. And this evolution will keep changing quickly, especially going into the new year once the pandemic is resolved and people come back to work and are handling more and more data. And that's my presentation. Are there any questions? I'm not seeing on the screen that there are, but Nick, fire away if you've seen any that I'm missing.
Yeah, and thank you, Romain, for that presentation. That really was fantastic. There were two parts that were very timely. You talked about, on the national level, some of the issues with some of the big social media firms and the questions around cybersecurity for those. And then also here in Utah, discussions about liability protections or the affirmative defense for businesses here in Utah. And so anyway, both of those things, as we all know and our viewers know today, have been issues that have come up in the national media. There was some movement on legislation last session here in Utah on the affirmative defense aspect. And so anyway, very timely information. And so we thank you for that. As we wait for questions to filter in, just again want to remind people, go ahead and plug in some questions or thoughts or comments in the Q&A tab here on the Zoom platform. And now's your chance to ask any cybersecurity related, legal related question for Romain while we have him for a few more minutes. While we're waiting for folks to plug in questions, Romain, I did want to circle back to something you said, referring to the FTC and kind of their advice on industry standards. What would you recommend for a business looking at this? And they obviously want to be compliant with what the FTC says and do things in a good way. What's maybe some of the first steps they could take as it relates to those FTC recommendations for industry standards?
Yeah, thanks, Nick. I think as a starting point, companies should know their data. And by that, I mean, know what they collect, where it's stored, how it's maintained, how long they need to keep it, why they're keeping it. And then from that point on, conduct a risk assessment. So when I met with the FTC Commissioners, they endorsed very strongly what's called the NIST Cybersecurity Framework, NIST CSF. NIST is the federal agency that develops standards, and they have developed a cybersecurity framework that is a guide that companies can use when building their own WISP, what the FTC refers to as a written information security program. And the WISP and the NIST, and I have it right here on my board, just the basic framework, it has 5 functions, or identifies 5 functions that companies should have in their programs. And then it has about 23 subcategories that a company should analyze and include, if necessary, based on what they collect in their programs. And an example of one of those things is an incident response plan. Most companies have in their employee handbook an incident response plan that relates to all incidents: an earthquake, someone slipping and falling, some kind of workplace injury. What NIST and the FTC and other regulators are saying is you got to have a cybersecurity incident response plan. And the NIST is a good place to look for that. But all companies should be including in their employee handbook cybersecurity incident response plan too. So risk assessment, incident response plan, and then training about the data they collect, why they collect it, how they should handle it, when they need to dispose of it, and what regulatory framework or what laws govern their use of that data. Training is being considered a must-have. If you're not training and you have an incident, a regulator is going to say, yeah, you weren't prepared for this, because in the first place, you're not even training people who are actually collecting this data on how they should handle it. So those are the top three.
And following up on the industry standards, you mentioned some of the acronyms there. If you were to say kind of what are probably the top industry standards that businesses can look at to comply with, maybe the top three or so that of course the FTC would support as well.
Yeah, so the NIST Cybersecurity Framework is one. It's dense. I mean, it's about 80 pages. It's abstract, but there are nuggets in there that relate to every business. That might be a little bit overwhelming. There's another set of standards called what's called the CIS 20 critical controls. You can Google that, and the CIS 20 critical controls is a set of guidelines around cybersecurity that were developed by the Center of Internet Studies, I forget, but it was devised at the direction of the former Attorney General of California, Kamala Harris, back when she was in charge, and data security and proper use of data privacy was a big part of her administration as an AG. So those critical controls, they contain guidance also. And then another one is, there are industries such as healthcare and banking that release guidance. Healthcare, through the HIPAA statute, has what's called the security rule. And under that rule, they provide guidance on what should be included in the securing of health information. And then the banking industry has something similar under the GLBA, the Graham-Bliley-Leach Act, which also has guidelines or must-haves that should be part of a banking program's security program. So NIST, CIS 20 critical controls, or some very even more dense guidance contained within HIPAA and the GLBA Acts in the healthcare and banking industries.
That's helpful. Thank you. Kind of following up on that one, a question from one of our viewers, James asks, can you remind us where to find the business legal requirements for cybersecurity? Business
legal requirements. Oh, okay. So, well, here's one of the sources I referenced was, if you Google Equifax versus FTC, you will find an order and decision, or I think it's also called a consent decree. And in that decree, which is the settlement that was signed between the FTC and Equifax, is a chapter or a section titled Mandated Written Information Security Program. And then it'll contain all of these technical requirements that, yes, okay, the FTC was saying the Equifax needed to implement. In fact, they mandated that they must. But back to what the commissioner said to me and my client, which was, what are the industry standards? Are we meeting them? Those are the industry standards. Now, not all of those technical requirements are going to be necessary for every company, but they at least establish the building blocks that businesses should consult and implement based on the data they collect, what industry they function in. That is a starting point. And then also what I just mentioned, the NIST, N-I-S-T, all caps, Cybersecurity Framework. I hope I answered the question.
Excellent, thank you. James or anyone else, if you want additional clarity, feel free to pop in another question to the Q&A tab. As folks are kind of stewing on that, kind of a big picture question. As business executives have a lot to deal with these days, and especially right now, there's been a lot going on in the world that's affecting our businesses. But cybersecurity is still important, and a lot of our previous presenters have talked about how, especially in this age of remote work, in some ways, cybersecurity is even more important for business leaders to be on top of. So thinking about the context of everything that business executives have to deal with on a daily basis, what would you recommend as far as how they can best use their own time and energy as it relates to cybersecurity, and of course, that of using their team? What's kind of your just off the cuff recommendation of really how to prioritize their time to be the most effective with this?
Yeah, often in most corporations, the cybersecurity professionals, the IT professionals, are overworked and understaffed, undermanned, and usually underfunded. So those being the typical starting points, the first step is really communicating with those team members about what they're seeing, what kind of vulnerabilities they see that they're not able to address, where are the risks. Again, this goes back to doing a risk assessment, and then sitting down with those people and prioritizing a way to approach those. So I help companies, I will help companies conduct a risk assessment, and I will retain technical consultants that will work with a company's existing professionals to formulate and understand the risks, and then come up with a 10-point plan to address those risks. Most companies, they could spot 30 to 40 risks relating to their systems. You're never going to resolve all of those in a year. Highlight the top 10 and implement a plan to at least address the first 3 in 6 to 12 months. And then meet again every quarter or every 6 months to say, okay, have we addressed those risks? What's next? So it's prioritizing them, just taking it one at a time, as much as time and budget will allow, and trying to resolve them. The worst thing a company can do is put their head in the sand and not even assess their risks. Like the AG quote I had says or implies, they want to know that you've at least looked and found where you are lacking, and at least plan or have a plan to address those areas. You cannot resolve all of them at once. So just pick the easy ones and try to resolve those with your team members and your cyber pros.
It looks like we don't have any other questions that are popping up in the Q&A window. So I want to again thank you for your time today, spending your lunch hour with us here at the Chamber and with the businesses who have tuned in for the presentation. Very timely, as I said, and the information has been incredibly helpful. As a reminder to those watching, we'll have this posted online afterward as well, along with all the other cybersecurity presentations we've had in this fall 2020 series. And this is the last one, so we want to thank everyone who's participated and who's presented as well, and remind everyone that for the participants of today's webinar, as well as all the others, we'll still be doing that opportunity drawing for the Series 5 Apple Watch. We'll follow up to the attendees for that. With that, we'll get ready to sign off. I want to thank again, before we finish, our Respond level sponsor, Strong Connections. Romain, thank you again for your time and your help. And we'll see you in the future for future cybersecurity events.
You're very welcome.
Thanks, everyone. Thank you.
Thanks, everyone. Bye-bye.